So, hello everybody, welcome to the Swiss Patent Litigation Fireside Chat. It's the 33rd edition already. It's quite a while ago that I started this series. Glad that you joined today. It's a very hot last Wednesday of a month today. And it's a special Wednesday because it's the day before a public holiday in Switzerland. So maybe if not too many people will join today, I would understand that. Maybe some of you are already on holiday, but you can listen to the Fireside Chat anyway later on, still on LinkedIn. So I skipped the last edition of last month. I was on holiday and well, not too much has happened that would have been worth to report. So I skipped the last edition, but today there's quite a few things to discuss. As always, if you have any questions or comments, feel free to leave a comment directly on LinkedIn. I will try to keep an eye on the comment section. I'm not sure if I will always see it, but I will in any event answer after the chat if I miss the comment. So let's directly dive into the decisions that I wanted to touch upon today. Now I'm gone, obviously. Why is that? There I am. Okay. So that's the first decision that I wanted to discuss today. That's summary proceedings S2024-003 between Bayer and Helvepharm. It's about this pharmaceutical, Xarelto, that's the blockbuster pharmaceutical of Bayer, by far the most important drug of Bayer. And well, there has been a basic patent, a compound patent that has lapsed already. There was an SPC on that lapsed already. Now there is still a dosage patent. I will come back to that in a minute. So the whole market exclusivity for this blockbuster is currently hanging by a thread of this dosage regime patent. Rivaroxaban, that's a compound in that pharmaceutical. It's always fun to look at the UPAC name and try to figure out how it actually looks like. It quite often takes a while until I get to the correct structure meanwhile, but here it is. That's the right structure. That's rivaroxaban. And here's a claim of that dosage regime patent. That's the independent claim of that patent, which is still valid. That's exactly the issue, whether it's valid or not, but it's in force. The interesting bits of this claim is the dosage regime, as I mentioned earlier, that the compound is administered no more than once daily for at least 5 consecutive days. And the interesting bit in that claim is that it also talks about the plasma concentration of 10 hours or less when in fact already administered to the patient. So yeah, plasma concentration of course varies between patient groups, age in that case. So what does that mean for infringement? That's an interesting bit. I'm not sure whether that is so clear, at least it's not to me. But back to the decision and what happened before the decision was issued. So the PI request was filed with the court on the 26th of June. And as is common practice, it was also requested that the were in the first place issued ex parte. And then what typically happens is that the defendant is heard afterwards, and then it's decided whether the PI is maintained or lifted. So that was pretty usual. And what the decision also says is that a few days before, on the 20th of June, defendant had filed a protective letter with the federal court. Now, what happened shortly thereafter, meaning roughly 2 weeks, 10 business days actually, after the filing of the PI request, the Federal Patent Court already issued a decision where the whole PI request was dismissed entirely. Not only the ex parte request, but also the inter partes people that would normally have started off in summary proceedings. So that was really a stunner. And here are the relevant bits from the decision. It's in German, unfortunately, but I will quickly translate it. So it was really a dismissal of the PI request for lack of inventive step of the patent in suit. So this bit of the decision was it's not credible. Well, one of the patent in suit is based on an inventive step. So it was a decision on the very merits of the case, inventive step, pharmaceutical case, which normally takes ages for the parties to write briefs, and at least takes a year or so, even in summary proceedings, to come up with a decision. That was really a jump start from filing the PI request to the decision of only about a month. Now, the next bit in that decision says, and that is pretty common, that the ex parte request was dismissed. And here is the final conclusion, which is the actual stunner. So if there is no basis for preliminary measures, meaning there is no valid patent, we can just skip any inter partes proceedings and can right away issue the final decision in summary proceedings. So that's what this bit says, with a reference to a commentary on the procedure code. That is a first. That has never been seen before in Swiss patent litigation, to the best of my knowledge. And yeah, that makes one thinking. And if you would assume that there is maybe more to rivaroxaban ongoing in Switzerland than is currently meeting the eye, that might be right, because it's really just extremely quick from filing the PI request. You need to remind yourself that the court has to compile a panel of judges in order to come up with a decision on the merits. So that takes a while, and then the whole assessment of the prior art, and that only business days is extremely quick. Now, what does that mean for maybe future, or how parties should make use of protective measures? Just think of it from a perspective of the defendant here. They only filed a PI request. Apologies. They only filed a protective measure because they were afraid that an ex parte injunction might be requested and be issued. And the only thing they were informed about after that was a PI request and parties, and we dismissed it all right away, and you were awarded 25,000 Swiss francs for your protective letter. That's pretty cool. That's very that underlines that protective letter, when it's really, really, really good and very convincing, and the facts are on your side, can be a very effective way to not only prevent an ex parte injunction, but to really completely get rid of any PI threat, even in ex parte proceedings. Yeah. So maybe it's also an attempt by the court to show that, hey, it's not given that PI proceedings always involve an exchange of briefs, statement of claim, statement of defense, and then the expert opinion of the judge rapporteur, which takes a while, and then comments on the expert opinion of the judge rapporteur, and then an oral hearing, which typically takes between, I would say, 9 months to a year. We can be quicker. That's a clear message here. It can, in extreme cases, be even 10 days. I recently stumbled across an article on Lexology, and I mentioned that already on the blog, that discussed the only two cases at the UPC that involved protective letters. In those cases, Swiss parties were involved, interestingly, and the headline of that article on Lexology was "Damned if you do, damned if you don't?" question mark. And really, just to give you an idea of these two cases, very, very roughly, the first one was between Revolt and Stromer. It's about e-bikes. And there was a protective letter on file before a trade fair in Germany. And the UPC took that protective letter into account and nevertheless issued an ex parte injunction. So the defendant's booth at the trade fair was shut down. So that protective letter apparently only had a non-infringement argument included, and that argument did not fly, and validity of the patent was challenged. So in the end, this protective letter was not only not helpful, it was counterproductive. The other case at the UPC where protective letters were at least mentioned is litigation between Orthovox and Mammut. It's about an avalanche rescue system. Ask me about the details. It really doesn't matter for now. But there was a warning letter issued by the plaintiff. Apparently, Mammut then filed a validity action with the Swiss Federal Patent Court. That's all good. You can do that, of course. So pending at the Federal Patent Court in that nullity case. But what Mammut did not do was filing a protective letter with the UPC. So what then happened was that the plaintiff Orthovox communicated the contents of the nullity proceedings in Switzerland to the UPC. They take a look at it, and well, they obviously found that in some other proceedings, those nullity arguments are not convincing. So they issued a PI ex parte, and they even blamed Mammut for not having filed a protective letter with the UPC, even though there was ample time to do so. So they felt free to only rely on the arguments they could view from the corresponding Swiss proceedings. They were not convincing, so ex parte PI granted. So here in Switzerland, I would say anything but damned if you do, damned if you don't, but I would rather answer blessed if you do it right. And maybe moving on the slides now, here are the numbers of protective letters filed in Switzerland. Always enormous numbers. 2023, you can see that on the slide. There were 77 protective letters filed in order to prevent ex parte injunctions in Switzerland. At least a few years ago, if you had asked me, is it necessary to file a protective letter? I would have said, no, it takes a few days anyway, or a week or so for the court to compile to staff the judges, and then looking into the case, always ask for comment in a regular case by the defendant when it comes to the discussion of nullity or inventive step and so on. So yeah, so necessary, maybe not, but with this decision now in mind, helpful, yes, and maybe even extremely helpful because it prevents an exchange of briefs, and it prevents plaintiff from a second chance to comment on anything, which is normally the case in written proceedings with an exchange of briefs and a hearing afterwards and so on. So I would guess that the numbers of protective letters will now even increase further, keeping in mind this one decision that dismissed the PI request entirely in one go. Sad for buyer, good luck for Helvepharm Zentiva in that case. Yeah, that's pretty much it for that case. Now, moving on to the next case. This is interesting because I know the file numbers of the proceedings at the Federal Patent Court. This is the first one, 02023-009. But I only know this file number from judgment of the Supreme Court, the Swiss Supreme Court. That's the right number, 48254, which refers to that file number of the Federal Patent Court. And yeah, we will go through that Supreme Court decision in a minute. It's very clear that this litigation between Nestlé on the one side. I'm saying Nestlé here. I can't tell which Nestlé entity or which legal entity in the whole universe of Nestlé connected undertakings is the plaintiff, but it is within the Nestlé group of companies. Believe me, I will show you that. And on the other side, it's obviously K-Feed that's within the Krüger group of companies. So it's about coffee capsules. You can see that already. Now, which coffee capsules? It's about these capsules. These are Goutchew capsules, and patents that are at stake in proceedings are patents about coffee capsules that carry a barcode, and you can see that on the rim of this capsule here. There is a barcode. Well, at least that's the face of it, but the whole discussion in infringement proceedings happened a while ago was whether that code actually is a barcode or a bit code. You can argue about that for ages. It was decided, well, that is not a barcode, it's a bit code, so the patent will not infringe. So the infringement claims of KP are, at least in Switzerland, of Zentiva. And now, next slide. I need to explain a bit about the background, what you can do under Swiss law when you believe that the applicant or the patentee of a patent is not the legitimate applicant, but rather you are. Then you have actually two chances. The one is based on Article 26, listing all the grounds for nullity. And letter T says that a ground for nullity is if the proprietor of the patent is neither the inventor nor his successor entitled. And it is established case law that this ground for nullity can only be invoked by the legitimate owner. So that's one basis how you can attack these patents. And the other basis is Article 29. You can file an action for assignment. So if you believe it's yours, then you can just go to court and request that it be transferred to you. That's what Article 29 says. And interestingly, in Article 29, it's mentioned, marked that the entitled person may apply for assignment of the patent or alternatively file an action for nullity. That's based on Article 26 on the slide before. So, which brings me to a judgment that was rendered last year already. It's a judgment of August last year. Proceeding were 2022-003. It's on the left. And that was this litigation between a Nestlé entity and KEFI. And the patents at stake here, I listed them here, were these three patents. And what Nestlé requested is on the bottom left here. There was um, a claim for assignment, but subsidiarily, it was also a claim for nullity. So those legal reasons were invoked, Article 29 and Article 26. So that's sorry, I spoiled that one. What I wanted to show you is the order of the Federal Supreme Court. That's this one here. Let us quickly scroll through that. So when you look at the top of the decision in the identifying the parties and representatives, it's Meyer Luschenberger for the appellant and Homburger for the plaintiff, defendant in appeal proceedings. Our silverbacks, obviously, Andre Hess and then Simon Holzer. I marked here the procedural number of the Federal Patent Court, and then the decision is, well, anonymized a bit, but well, when you follow the FBC proceedings, you pretty quickly get an idea of what's at stake. So here in blue are 4 patents mentioned. And as I mentioned just a minute ago, there were 3 patents at stake in the assignment action that has already been decided finally and binding up to the Supreme Court. So I first wondered what's the 4th one. But that will be about later. So what has happened here in this order of the Supreme Court? So obviously there was a request to declare the patents void based on Article 26, and what defendant or patentees here in that case argued, well, you should not consider that claim anymore. It is already judicata, so to say. You don't even have to consider that case. And on a procedural level, it was requested that the proceedings at the Federal Patent Court should, in the first place, be limited to the question of whether the complaint is admissible. And subsidiarily, the whole proceedings should be stayed until the German proceedings at the Oberlandesgericht, I think it's Düsseldorf, has decided about the assignment actions for the other national parts of the patent family. So the assignment action in Switzerland only related to the Swiss Liechtenstein parts of the European patent, and the other parts, in my understanding, are currently being dealt with at the Oberlandesgericht Düsseldorf in Germany. So that is all also been known from the Swiss assignment proceedings a while ago that I mentioned. Now, what did the president of the Federal Patent Court do? He said, "Well, I dismissed the one that's more up here on the first line of that page, and also the procedural requests on the second line are dismissed." What can be obviously then challenged in the first place that, well, the president has not the power to dismiss the request one. So not only the procedural request, but the whole admissibility challenge. The whole, he has not the power alone to decide that. So that kind of judgment judges was wrongfully staffed, so to say. So that was challenged. Blah, blah, blah. That is all good. The Supreme Court, well, uh, said, well, it's maybe a bit misleading, the wording, how the decision of the president was worded, but there are at least two different interpretations of that thing, and in consideration of the reasoning the president made in that order, they believed that it was only dismissal of a procedural request, and he has the power to do so. Um, so, yeah, that was pretty much the end of that story. Interestingly, here, marked in blue, there is a patent number in plain text. So almost never anonymization really works in a way that prevents that third parties get an idea of what's at stake. So that is exactly the fourth number that was not at stake in the prior Swiss proceedings. Now we have four patent numbers that are at stake. I think I made them here. Yeah, you can see that here. It doesn't want to stay. Yeah. So the first three are the ones that have taken into assignment action already, and the fourth is a new one that has been mentioned in the Supreme Court decision text. So we have all the bits together. So the operative part of the decision of the Supreme Court is, well, I'll consider that appeal. So now the court is the proceedings will go on, and yeah, let's see how that plays out. Obviously, as mentioned, top part here, yeah, it's here. The parties asked the president of the patent court that proceedings were stayed until the federal Supreme Court has decided about the appeal. And well, that's what the Federal Patent Court did, and the Supreme Court decided now, so proceedings will go on at the Federal Patent Court. We shall see how that plays out. Now, yeah, that's what I had on the screen already a few minutes ago. The whole case, when I saw that order of the Supreme Court reminded me of this guy here. Well, I'm a child of Western Germany, right in the middle between Dortmund and Schalke. So that guy is Wolf Rüssmann. He's well known for a quote. This one here: "If we don't win, then we will at least destroy the grass." That was in the days when he was for Schalke, and before Schalke had to play in Dortmund. Later, he played for Dortmund. That's a hard move in that area of Germany to move from Schalke to Dortmund. Anyway, but as I said, there are silverbacks on both sides. So I think there will be merit on that nullity case, and yeah, we will learn about that more. And finally, the Federal Patent Court issues a decision in this matter. Now, moving on to the next one, that is a case that I'm not yet sure about how to deal with that. It's again a nullity action, as they are represented again by a Hamburger, Andre Hess, and it's very clear that the plaintiff of the nullity suit is again an entity in the Nestlé universe. Because the whole factual background in that order of the Supreme Court, the number is on the right side, is the same. It also refers to the assignment action in Germany, so it's very clear it's Nestle against whom. Uh, it, it's pretty unclear to me, and it does not where the factual background in the Supreme Court order differs is with reference to the prior proceedings at the patent court against KFI. So I don't think that the defendant is KFI in that case, but it must be a very closely related patent that is being challenged here by Nestlé. And if you know me, I have an educated guess, and my educated guess is this one here. That's a very closely related patent number. As you will recall, the 207 and the 209 and the 210 patents were at stake. And here is again another one, the 208. That one has been initially filed by KFI 2, and it has been later assigned, I think in 2019, to Krüger Cafe Holding. So a different entity in the Krüger universe of companies. So my educated guess is that this patent is challenged in the second case. Well, I stand to be proven wrong when the Federal Patent Court issues a decision in that case. Interestingly, the defendant here acting on behalf of the Krüger side, so to say, different entity in the Krüger universe of companies, but still for the Krüger side. That's not Luxembourg in that case, but it's Lenz and Sterling, Terry Cullen. Yeah, yet another silver back. So yeah, it's about coffee capsules. What do you expect? Okay, so moving on to the next case. That's not because I want you to have a great holiday. I, of course, want you to have great holidays, but it really relates to the next case. It's about ducks. It's about Duckface. That's a decision that was only published on Monday, I think. Yeah? On Monday, that's S2024-002, between a natural person, French guy, against various legal entities, companies, and various natural persons. I only put the first one here, Metcalf. Yeah, and this here is the attacked embodiment. It's called Duckface, and the company is not sure how to pronounce Goutchew. So Duckface from the company Goutchew is the attacked embodiment, and the patentee's product is this one. That looks pretty similar, and his brand is Froggy Mouth. So it's Froggy Mouth against Duckface. I can't make that up, but yeah, that's what it is. So that's a patent at stake. So the Federal Patent Court in the first place dismissed an ex parte PI request. So as I said before, with respect to the Bayer case, that's what you request always. You have to be quick if you request that, simply because there's a very short time frame of only 1 or 2 weeks or so, depending on the case. And here it was already undisputed that about 3 months lay between the actual knowledge of the infringement and the filing of an ex parte PI request. So that was a no-brainer. That ex parte PI request was dismissed. But then in the inter partes proceedings, the Federal Patent Court went through the statement of defense and, well, addressed all the questions it has to address and answer. Is there an infringement of that patent? Well, that was not even contested. So infringement given. Validity of the patent, is it valid or not? Well, validity was not contested either. And then the next bit was defendant said we stopped marketing of that product, but they did not file a cease and desist declaration. So there was no binding declaration that they would not do it anymore or any further or again in the future. So that was also not available. So that was a pretty easy case for the Federal Patent Court and to just move on and issue a PI. That is, it was a bit surprising to me when I read that decision that, well, nothing was contested, no cease and desist declaration on the binding level. It was pretty clear that a PI was to be issued, and that's what happened. As always, I was a bit nosy about the background of the case. I read in the decision, well, number of items sold. What's your guess? It's two, really, literally two items were sold. Okay, that's not much. I wanted to get an idea of the price of that device. I went to the website. So the decision identified the name of the product, Goutchew Duckface. That's what I googled here. First two hits are from the defendant. The third hit is the decision from the Federal Patent Court, and I will come back to the fourth hit in Google in a minute. So yeah, Google Goutchew Duckface, and then click on the first hit. You get to the web shop of the defendant, and the price is obviously 34 Swiss francs. Okay, I gave it a try and choose a size. I chose S here. No idea what that means, but anyway, I chose S, and it says it's available on stock. Okay, let's put it in the basket. Now the basket is filled with that one device of 34 Swiss francs. Okay, I gone to the basket. Here it is. I could even move to checkout, but that's where I stopped. I really have no interest in that device. But yeah, I wondered, that's still exactly what is forbidden, isn't it? And indeed, the that's what the president decided. The first clause of the operative part of the decision is the typical prohibition to market, sell, blah blah blah, and so on. And then the second item is what is on the screen here. It explicitly says that it's ordered to delete the content that is available under that URL that I had on the screen before. Yeah, that decision was issued on what is it, 15th of July, I think. It's 31st today, so yeah. I have a vague feeling that somebody is currently infringing on that order, but yeah, yeah, that's not up to me to decide. I just wondered. Yeah, as I said, that was on what I had on the screen already a few slides ago. I said that I will come back to the fourth hit in a minute. I will do now. Of course, I got nosy when I read Duckface is not what is now hip in Generation Z. It's a scrunch face. I had no idea what a scrunch face is, but obviously it's when you try to make as many cringes in your face as reasonably or unreasonably possible. So if you want to be hip now, you don't make a duck face, but rather a scrunch face. And no, I will not make either a duck face nor a scrunch face now. I tried it this morning. It doesn't look good on me. So yeah, that finally brings me to the end of this week's Fireside Chat, this month's Fireside Chat. As I said, it's a Wednesday before a public holiday in Switzerland. It's the national celebration, 1st of August, national holiday. So that's the way how the biggest mountain in St. Gallen, Sentis, will be looking like tomorrow with a Swiss flag. So For the Swiss people listening today, enjoy tomorrow, the break or the prolonged weekend, maybe if you make the bridge over to the weekend on Friday. Thanks for joining, everybody. I hope you will join me again next month on the last Wednesday again, last Wednesday of August. Thanks for listening. Thanks for joining.